Hello students, my name is Dr. Alice Mani. I will be imparting lessons on Business Law, course 306. I am the resource person for Mahatma Gandhi National Council of Rural Education. I will be imparting lessons on business law. This is part of the BBA Rural Management course. This unit, that is chapter 3 titled Sale of Goods Act 1930, will be covered in 4 modules. The first module will look at the basic features of the Sale of Goods Act 1930 and types of goods. The second module will cover conditions and warranties. The third module will cover the rights of an unpaid seller. The fourth module will cover duties of buyer. We will cover second module of the third unit, which is conditions and warranties, in this video. So let us go ahead and understand the topic in details. I have structured this lesson in the following way. This lesson will cover 4 broad topics. The first will be an introduction to conditions, distinction between conditions and warranties, and implied conditions. Second is a detailed explanation about implied warranties. The third will cover an explanation about implied conditions and implied warranties. The fourth and last module will cover the doctrine of caveat emptor, the most important principle in Sale of Goods Act, that is, let the buyer beware. The first module objective is to understand the structure and nature of conditions and warranties. Second objective is to equip you with the knowledge of implied conditions. The third objective is to provide insights about implied warranties. The fourth objective of this module is to provide insights about the doctrine of caveat emptor. At the end of this lesson, you will be able to understand the basic features of conditions and warranties, implied conditions, implied warranties, and the doctrine of caveat emptor. Thus, you will get information about legal consequences for breach of conditions and warranties and the privileges and consequences of buyers and sellers with regard to conditions and warranties. Also about the doctrine of caveat emptor. This will be helpful for those who will become entrepreneurs in future or to understand the basic legal implications as consumers. This will equip us with the basic knowledge to be more alert and responsible in protecting our legal rights as consumers. The seller or as a buyer. Moreover, the knowledge about the conditions and warranties will guide in entering the right transactions and not to get cheated, either in the online or offline mode of purchase. So let us understand this topic in details. Let us now discuss about the importance of condition in Sale of Goods Act 1930. According to Section 12, subsection 2 of the Sale of Goods Act, a condition is a stipulation essential to the main purpose of the contract, breach of which gives rise to a right to treat the contract as repudiated. The meaning of repudiation is to reject the contract. Now, let us understand the meaning of condition with suitable examples. Have you heard of these terms, conditions and warranty? I mean conditions and warranties in relation to Sale of Goods Act. I don't think so. So let us understand these terms in details. In a contract of sale, parties may make certain statements about certain stipulations with reference to the subject matter of sale. For example, if it's for negotiations for selling a car, statements like single owner, fuel efficiency, kilometers travelled, etc. These stipulations may either be a condition or a warranty. Conditions are certain obligations terms and provisions imposed by both parties in a contract of sale of goods. Conditions are indispensable and they need to be satisfied. Conditions are obligations that a party is required to fulfill to complete sale. The breach of condition will give the right to affected party to cancel the contract and claim for damages. For example, Mr. A wants to purchase a car from Mr. B, which can give a mileage of 20 kilometers per liter. Mr. B pointing at a particular car and says that this car will suit you. Later, Mr. A bought the car but found that this car has a mileage of only 15 kilometers per liter. This amounts to a breach of condition because the seller made the stipulation which forms the essence of the contract and hence it's a breach of condition. Now, what is a warranty? A warranty is a written guarantee that a seller issues to a buyer regarding particular claims. The claims are to be factual and valid. An example of a warranty is a seller committing to replace or repair a product within the specified time if it does not meet the expected performance. For example, a washing machine is sold with 1 year warranty. This guarantee can be about fitness, quality, and the performance of the sold product. A warranty acts as a confirmation that the product will complete conditions and run as promised during the specified time. It is the seller's assurance or promise to the customer that the goods are in their best condition. If the warranty is proven false and the product fails to perform as described, the seller may seek remedies as stated in the contract, such as exchanging or returning the item. Let us make it clear with an example. Mr. A purchased a car from Mr. B, who claimed that it is in good condition. Mr. A found that after a few days the car is making loud sound while running. In such a situation, Mr. A can claim damages for the amount he had spent for repair. This is a breach of warranty as Mr. B gave only a collateral stipulation that about the car's condition. It is important to remember that whether a stipulation is a condition or warranty is based on how the contract was made. Let us see how we can distinguish between conditions and warranty. There are 3 differences between conditions and warranty and we have to learn these points. They are relation to the main purpose, difference as to treatment, difference as to breach and importance. Let us see these points in detail. Condition is a stipulation essential to the main purpose of a contract. But a warranty is a stipulation which is only subsidiary or collateral to the main purpose of the contract. The second distinction is based on importance. Conditions have to be satisfied in order to complete the contract. But the main contract can be completed even if the warranty is not fulfilled. The third distinction is based on difference as to breach of condition or warranty. If there is breach of condition, the agreed party can cancel the contract. But for breach of warranty, the agreed party can claim only damages. The last distinction is based on difference as to treatment. A breach of condition can be treated as breach of warranty, provided the agreed party is content with the damages only. But a breach of warranty cannot be considered as a breach of condition. The next important concept we have to learn is about the express and implied conditions. Express and implied contracts we have learned in the Indian Contract Act 1872. So you are familiar with these terms, express and implied. So let us understand what are implied and express conditions. An implied condition is when it is neither written nor declared by any party, but it is automatically implied by law. Unless a contrary agreement is made, these conditions continue to be valid on a sale transaction. For example, you go to a fruit vendor and ask for seedless grapes. If the fruit vendor gives you seedless grapes, there is an implied condition that the grapes are actually seedless. But later, when you found that it was not seedless grapes, you can reject the item. Implied conditions on the sale of goods include conditions based on the title, description, sale by sample or by description, quality, merchantability and wholesomeness. These conditions we are going to learn in detail in a while. Implied conditions are the ones which are not written or expressed while the sale of goods is commenced, but exist by default as per law. On the other hand, express conditions are specified and discussed between the buyer and seller before agreeing on a contract of sale. For example, a company sells certain belts made up of a special material by sample for the Indian Army. The belts are later found to be made of plastic and not leather, which is not discoverable by ordinary inspection. In this case, the buyer is entitled to refund the price plus damages. I hope that now you got the difference between express and implied conditions. Now, let us learn what are implied conditions. I have told you earlier that we will learn these points in detail. The following are the implied conditions. The first implied condition is condition as to title. In simple words, in every contract of sale, there is an implied condition that the seller has the right to sell. This implied condition is applicable if it is a sale or agreement to sell. The reason is in a contract of sale, ownership has to pass from seller to buyer. If the seller's title turns out to be defective, the buyer can reject the goods. The second implied condition is sale by description. In sale by description, the law implies the condition that goods should correspond with the description. If they do not, the buyer can reject the goods and it will not be of any defense to say that it will serve buyer's purpose. For example, if a wholesaler wants to buy basmati rice from Bhutan, it should correspond with the description provided by the wholesaler. The third condition is condition as to quality or fitness. Normally, there is no implied condition that the good shall be fit for particular purpose of the buyer. It is the duty of the buyer to see and satisfy himself whether the article will be suitable for the purpose for which he purchased. But there is an implied condition on the part of the seller that the goods supplied shall be reasonably fit for the purpose for which the buyer wants them, provided the following conditions are fulfilled. The buyer should make known to the seller the particular purpose for which the goods are purchased. This is the first condition. The second condition is the buyer should rely on the skill and judgment of the seller. The goods must be of a description dealt with by the seller, whether he is a manufacturer or not. This can be made clear with the case decision Baldry versus Marshall in 1929. In this case, Mr. Baldry went to a car dealer, Mr. Marshall, and asked for a car which is suitable for touring purposes. Mr. Marshall suggested Bugatti car. Remember, it's in 1929. Now we don't know about this type of cars and all, but this happened in 1929. So Mr. Baldry bought the car, but it was later found to be not suitable for touring purposes. It was held by the court that Mr. Baldry could return the car and recover the price. The next implied condition is condition as to merchantability, where the goods are bought by description from a seller who deals in goods of that description, that there is an implied condition that goods shall be of merchantable quality. There are two conditions to be satisfied and two requirements for this condition to apply. That is, goods are bought by description. The seller should be a dealer in goods of that description. The word merchantable quality would mean that the article is of such quality that a reasonable man acting reasonably would accept it under the circumstances of the case, whether he buys it for his own use or to sell it again. For example, Mr. Raman, the owner of a stationery shop, sells a house to Reena. Here, no condition of merchantability applies because Mr. Raman is not a property dealer. Miss Reena should be aware that Mr. Raman could not be held liable in case the property purchased by her is not a valid sale, because he is dealing with stationery items and not with the property. The next implied condition is condition implied by custom. This is applicable in the purchase of items like wheelchair, perambulator, hot water bag, feeding bottle, etc. The buyer need not explain the purpose for which he is purchasing the item. It is evident from the nature of description of articles purchased. The next implied condition is sale by sample, where a sample of the ordered product is provided to the buyer and the parties treat the sample as of a standard quality for sale. There is a condition that the goods will conform to the sample. Such sale is termed as sale by sample. In the case of a contract of sale by sample, there is an implied condition that the major part of the product shall correspond with the sample in quality, that the buyer shall have the opportunity of comparing the major part of the product with the sample. Second is that the goods shall be free from any defect making them unmerchantable, which would not be apparent from the reasonable examination of the samples. For example, when we order things online, the features, price, color, etc. will be provided. We will place orders based on the sample provided. When we get the purchased item, if it does not correspond with the sample provided, we can reject the item. The last implied condition is condition as to wholesomeness. The condition of fitness of merchantability requires that the good should be wholesome, that is, fit for the purpose of human consumption. This condition is a part of the condition as to merchantability. It is applicable in the case of food items and other goods which are used for human consumption. As per this condition, goods sold must be fit for human consumption. We have learned in the earlier module about Food Safety and Standards Authority of India and how government is ensuring good food fit for human consumption with the regulations from time to time. Now we have to learn about the implied warranties. Implied warranties are three, that are warranty as to quiet possession, warranty as to freedom from encumbrances, and warranty to disclose the dangerous nature of goods to the innocent buyer. Now let us learn these implied warranties one by one. Unless the circumstances of the contract are such as to show a different intention, the following are the implied warranties in every contract of sale. The first implied warranty is quiet possession of the goods. In every contract of sale, there is an implied warranty that the buyer will have and enjoy quiet possession of goods. If buyer's possession is disturbed by anyone having a superior title than that of the seller, the buyer is entitled to hold the seller liable for breach of this warranty and he can claim damages from the seller. In simple terms, the seller is the owner of goods or person authorized to sell the item on behalf of the owner, like a property broker or share broker. The second implied warranty is freedom from any charge or encumbrances. In a contract of sale, there is an implied warranty that the good shall be free from any charge or encumbrance in favor of any third party, not declared or known to the buyer before or at the time when the contract was made. If the goods are found to be subject to a charge in favor of a third party, the seller is liable to the buyer to pay damages. For example, Mr. A wants to sell his house property to Mr. B, which is mortgaged with a bank for a business loan. Then Mr. A is not the actual owner of the property. He will get the right to sell the item free from encumbrances when he repays the business loan. The last implied warranty is to disclose dangerous nature of goods. If the goods are inherently dangerous or likely to be dangerous and the buyer is ignorant of the danger, the seller must inform the buyer of the probable danger. If the seller fails to do so, the buyer is entitled to claim from him compensation for any injury suffered by him. For example, if a shopkeeper sells pesticides or crackers, he will explain the inherent danger of the product and will advise the buyer to keep it away from the reach of children. Now, we will learn an important concept in sale of goods, that is doctrine of caveat emptor. Caveat emptor is a legal term of Latin origin. I hope that you heard this term. This is quite commonly used in all transactions. It literally means that let the buyer beware. However, this does not free the seller completely from any responsibility. The doctrine of caveat emptor means that the responsibility lies on the buyer of goods and he must perform due diligence before the purchase of the goods. It is expected from the buyer to be alert in a contract of sale. He cannot hold the seller responsible for inferior goods unless the contract is based on fraud. The doctrine of caveat emptor is generally applicable in case of property transactions, but it can be applied in the sale of goods and other services. Though the responsibility lies with the buyer, he can shift it to the seller under the given conditions. If the buyer has informed the seller about the purpose of the purchase before making the purchase, if the buyer relies on the technical expertise and the experience of the seller, like for example, property brokers or share brokers or vehicle brokers. If goods are of a description that the seller supplies in his normal course of business. Example, Mr. A informs Mr. B, who is a shoe seller, that he wishes to purchase shoes for running. If Mr. B still sells Mr. A the shoes that are not fit for running, then Mr. B can be held responsible. Our learning wouldn't be complete if we don't assess what we have learned. So here I am giving you one activity. Doctrine of caveat emptor means let the buyer beware. Similarly, what is the doctrine that imposes a greater responsibility on the sellers themselves for the goods and services that they sell? Write a brief description about it. Now that we have reached the end of this lesson, I hope that you have learned the meaning of conditions and warranties, express and implied conditions, implied conditions, implied warranties, and the doctrine of caveat emptor. I hope that you got a good insight on the topics we discussed in this module. To conclude this chapter, in this chapter of Sale of Goods Act, The first module covered the basic features of the Sale of Goods Act and the types of goods. The second module, which we covered now, is about conditions and warranties. The next module is about rights of an unpaid seller. And the fourth module will be the duties of the buyer. Until we meet again, bye and thank you.